All right, Marina, are we ready to go? I think so.
Yes.
Awesome. So thank you all for joining us today. We are here for one of our continuing webinars on the HIV Housing and Employment Project. Today we will be hearing from some experts around immigration and documentation. Can we go to the next slide, Marina? So as always, this webinar is being recorded, and the recording will be available via Basecamp after the webinar. You can use your computer or telephone audio to hear the webinar, but all attendees will be muted. We constantly struggle with background noise, so we have decided to mute everybody. If you want to comment or you're having technical difficulties, let us know using the chat box. And then if you have questions, again, feel free to use the chat box. Ooh, we are flying through slides. So today we are going to hear, oh, and that's me. Next, sorry. So today we're going to hear from our colleagues at CHILPI, who many of you, I hope by now, have had some sort of interaction with. We will hear both from Amy Rosenberg and Marianne Smozak, who work for CHILPI at Harvard Law School. CHILPI stands for Center for Health Law and Policy Innovation. And they work to improve the health of underserved communities and reduce health inequities, focusing on low-income people living with chronic conditions such as HIV. We're also going to hear from Iris Gomez, who is a senior staff attorney at Massachusetts Law Reform Institute. She directs the Immigrants Protection Project, and she's a nationally recognized immigration law expert with decades of experience. She also teaches immigration law at Boston area law schools. Oh, and there's Amy's lovely dog, and there's Marianne's lovely pup. Very cute, Dragon and Pluto. So today our learning objectives. We will be identifying and defining the most common types of immigration statuses. We'll talk about public charge and proposed changes. We'll also describe how different immigration statuses may affect clients' opportunities to work. And we will describe how different immigration statuses may affect clients' opportunities to secure housing. But this webinar will not. It will not train you to recommend or guide someone through decisions that impact their immigration status. We recommend that you seek out a professional for that. Next slide. So I'm going to turn this over to Iris, who is going to get us started. And thank you. Thank you all for being here.
Thanks, Jane. So the first question people often ask is how immigrants get here legally or without documents, and usually it boils down to family relationship, employment, and humanitarian criteria that are sort of the three pillars of U.S. immigration law. Next slide. So people who come to the United States and people who are born in the United States may both be citizens, and this slide is the different pathways that a person can obtain citizenship. So the first, of course, is through birth in the U.S., including in Puerto Rico, which is a territory of the U.S., and secondly, through the naturalization process, which is a method by which someone who already has a green card can become a permanent resident, and after a certain amount of time in the U.S. with the green card, there's a process. And then the last two are sort of more wonky ways of acquiring or deriving citizenship based on relationship. And there are special laws that have been passed for years and years that depending on the year the person was born, qualified them for citizenship through the parent, either the parent's naturalization or the U.S. citizen. This is important just to know that sometimes when you're working with a client who thinks that they are an immigrant, in fact, if they tell you that there is a citizen parent or grandparent in their family, then you might want to have them be referred to someone to see whether, in fact, they might be a U.S. citizen. Okay. Non-citizens, next slide. So non-citizens are called aliens under the immigration laws, which is a pejorative term, but that is what the laws use. And they come in many different statuses. There's more than 24 immigration statuses. How they are acquired depends on, it could be employment, as you can see, skilled workers, professionals. In some cases, it may be humanitarian reasons, including the need for medical treatment. And the right that they each have to stay, work, and qualify for a public benefit varies by status, even if they are lawfully in the U.S. Many lawfully present immigrants are not eligible for many different kinds of benefits. And then the last bullet is people who are not here with any status. They have no currently valid document, and those are the people we talk about as undocumented and who are pejoratively called illegal aliens. Next slide. So a lawful permanent resident is the closest thing to a U.S. citizen under immigration law, in that they have a legal right to live, travel, and work here indefinitely, permanently. And the only caveat is that until they become citizens, they can still be removed or deported if they commit certain disqualifying acts. So these are examples of some green cards that you see on the left. The other kind of document you may see would be a temporary stamp in the person's passport. So when you get your green card, let's say through a family relationship in another country, at the airport when they come in, they will have a stamp that they've been admitted as a permanent resident. So they're sort of a green card holder too, even though they don't have the actual card yet. That has to be produced. Green card status can follow another immigration status, one of the ones we're going to talk about later. And it can be based on a variety of things. There are relationship pathways, employment pathways, being here for many years continuously pathways. There's a diversity visa lottery pathway, and some people are here, get green cards under special laws that permit one status to convert to green card after meeting certain requirements, or they can be from a particular country. There are many countries that have special laws conferring ability to get a green card because of being a national from them. So these are some of the ways a person becomes a lawful permanent resident. Next slide. There are a number of statuses related to fear of persecution or having been persecuted in the home country. So refugees and asylees are essentially the same status, except that a refugee is a person who comes here with that status, and the asylee is a refugee who gets that status after they're already here. There are some other less frequently seen persecution-based statuses that have different requirements but are similar, and one of them is called withholding of removal or deportation, and another is pretty obsolete. It's called conditional entrance status. Very few people have it anymore. All of these statuses are based on these humanitarian criteria, And a difference is that refugees and asylees can apply for a green card through a pathway available to people who have been asylees or refugees and still are. That doesn't mean that all the people in these bullets can't apply for a green card through another pathway, such as a family relationship, marriage to a U.S. citizen, for example, but there is this special vehicle for refugees and asylees to, in a sense, transition to green card holder. Next slide. Parolees are a very strange word to use because they're a category of lawfully present immigrants. But what happened is that many years ago, when we used to have Ellis Island and Angel Island, and people were admitted and had to be allowed in, but their processing was going to take some time. The government needed a way to let them go into the interior without actually formally being declared admitted. And so this weird parole status was created. But since then, it's morphed into, you know, something that is used more often for humanitarian reasons. Sometimes you'll see people who have had parole status granted at a port of entry because they had an urgent medical issue or some other public interest reason. So the other group, lawful temporary residents, are people who came here under a and were allowed to apply for status under a 1986 immigration law that was called amnesty. And you don't see too many of these folks because they should already have converted to a regular permanent resident, a green card holder. Next status. Victims of trafficking. So we have this victims of trafficking law, and we have increasing body of international and state laws that protect children, women, and others who have been exploited or abused, trafficked into the U.S. for many nefarious purposes. And these special laws guarantee them under federal law to be treated as protectively as refugees with respect to benefits. And so they have an enhanced protection. And unlike some of the other immigration statuses that we've been discussing and will be discussing, in order to be treated as a victim of trafficking for benefits purposes, they don't actually have to have a green card or some other document from immigration. If they're under 18 and they're a trafficking victim, that should be sufficient. Or if they get a letter from Health and Human Services explaining that they are a trafficking victim, then they would qualify, although they actually do have a pathway to legal status in the form of a T visa. Next slide. Non-immigrants are probably one of the largest groups of people you see, and there's dozens of categories of non-immigrants. The most common, of course, is a tourist. Again, this is a term of art, non-immigrant, because they are non-citizens and they're coming here in a migratory process, but some of them apply for the status from within the U.S., but they are generally supposed to have an intention to return to some home abroad, and their purpose in being here is more specifically defined in terms of time and objectives. And so the most common are tourists or B visitors, but we have an increasing number of people who fall into non-immigrant statuses that are that put you on a pathway to a green card, and one of those is something called the U visa, which is for a victim of certain types of crime who, after a certain amount of time in that status, can then go on to become a apply for permanent residence. So the majority stay in that status or switch to something else, but there are a few of them that provide this pathway, like the U's. So go on to the next slide. And then lastly, there are many other lawful statuses, and so as not to be overwhelming, we've just listed some of the main ones here. One that is familiar to many people are dreamers or young people who came to the U.S., who were brought here by their parents when they were undocumented, when they were young, and dream of a life, a better life in the U.S. And so under the Obama administration, they were provided with something called Deferred Action for Childhood Arrivals, or DACA status. So they're lawfully here, they have documents, but they're in one of these groups. Another big group are people with temporary protected status, which is a form of status that is granted based on a country of origin that has a natural catastrophe or has had some kind of major problem that imperils the return of the nationals. So for example, we have this right now for El Salvador, we have it for Haiti, and we have it for a number of countries that are listed on the USCIS website, which is updated frequently. Another group of people are applicants. So they could be applicants for a green card, applicants for asylum, or they could be applicants for DACA or TPS or many others, parole. They could simply have applied, and in general, an applicant has legal presence here because they have a right to have their application decided. So they have the right to be here while that application is being considered. I mentioned U visas, that they are, within this category of other lawful statuses as well, and including as applicants. And then I just wanted to mention a classification that is important for benefits purposes, called Cuban Haitian entrant. And this is it's not an immigration status, so to speak, but people who are Cuban and Haitian can have various different kinds of statuses, not the TPS ones, but other statuses that give them a special eligibility for many benefits and for employment services through the Federal Office for Refugees and Immigrants and their contractors, or their community partners, their NGOs. So even though it's not technically an immigration status, the immigration statuses that are considered Cuban Haitian entrant are very important to ascertain, to see if those people qualify for them. And I just have a note there that the documents, we're going to talk about employment authorization documents and other documents, but the immigration documents issued to all of these lawfully present immigrants may all be very similar. They may have the same employment authorization card, the same I-94 card, the same receipt, etc., but they will be coded in some way to indicate what their status is. So next slide. The next slide is, indicating undocumented, and these are just some of the ways that people get into the U.S. And become undocumented. So one is, you come as a tourist and then you stay for 10 years without any documentations after your tourist visa or other visa expires. Another is that you sneak across the border and no one catches you. And another is that you appear at the port of entry and you don't have any documents that are valid. So there are limited ways that people get in and out get into the U.S. Next slide. So this is just a list of some of the common immigration documents. It's not a complete list by any means. At the top, you can see some of the documents to establish citizenship. And below, I'll just highlight a couple. We've gone through the green cards, but the EADs are the employment authorization documents, the laminated cards that I talked about. Another very common card or document is the I-94, which is most customarily given to people when they're entering the country at the port of entry, or in the case of, for example, asylees or parolees, they might actually get an I-94 or be authorized on an electronic version of an I-94 by officials within the U.S. And then the next is a list of additional kinds of documents that help you ascertain what the person's status is. Next document, or next slide. Okay, now we're going to shift a little to talking about some of the immigration consequences of receiving public benefits. Next slide. So the primary way that that this comes about, this intersection of receiving benefits and facing an immigration consequence, is through the public charge test. So since the 1800s, we've had immigration laws that restricted the acceptance of people who are considered paupers or unable to show that they were not likely to become a public charge, which is a somewhat antiquated expression, but has continued to have vitality in immigration cases where people are seeking certain kinds of legal status, which I'll explain. But the main test for immigration officials to decide that is whether a person is likely to become primarily dependent on government-provided benefits, and we'll talk about which kind of benefits that means. Next slide. So first, the consequences of being determined a public charge or negative treatment because of public charge considerations. The primary negative consequence is the denial of a green card. Now, not all green card pathways are subject to the public charge rule. So if you're trying to get your green card because you were an asylee or refugee, as I was explaining earlier, through that special pathway for them, then having received benefits or anything else that might make you a public charge doesn't apply to that, because these are folks who are exempted from public charge because Congress realized that they would have no resources and needed to be dependent on the government in some way. So other pathways, for example, the most common one is through a relationship to a U.S. citizen spouse. That's called adjustment of status to permanent residence that way. That is very much subject to public charge test. So that is a difference in the applicability of public charge. The other two don't occur as often. The other two consequences being refused admission at the border because you're likely to become a public charge, because usually people have already been screened for public charge by a consular post, whether they were coming here on a non-immigrant visa or whether they're coming on an immigrant visa. So it would be less common that it would come up, although it's possible that it could have that consequence at the border too. And the last way of consequence is removal or deportation from the U.S. But this is very rare, and for the last 50 years, it's really almost not happened. So that could change, you know, in this administration. We know we've had a lot of policy changes, but that is less of a consequence than the others. And then you see there it says only applies to some applicants for status, and I would just caution that many of the lawful statuses that I described, like TPS, asylum, for many of those statuses, there is no public charge test. So at least with respect to seeking that status or a green card based on that status. But sometimes people who are exempt because it doesn't apply to them choose another pathway to which public charge does apply. And that is one reason why those folks should definitely consult with their own attorney about how it applies in their case. Next slide. So how the public charge rules currently work is very clear. It has to be that the person is likely to become primarily dependent on the government for subsistence, either because they've received cash assistance designed for income support, and that includes SSI and TANF, which used to be called welfare, and state equivalents of that, or the person is likely to be in government-funded long-term institutional care. So a caveat is that cash assistance for these purposes does not include earned benefits like Social Security retirement benefits or certain government pensions, et cetera. Those things don't count that way. And the government doesn't just look at benefits, right? Public charge, even if you never received 1 penny of cash benefits or any other kind of benefit, if your income is too low, you're extremely unhealthy so that you are unable to work and support yourself, you have no one else to support you, you have limited ability to show self-reliance under the listed factors, then you can still be determined to become a public charge. And then there's the last thing about this is that there is a difference in the last year since 2018 in how people have to get their green cards or other visas abroad, who have to leave, who they've been in the U.S., they leave the U.S. and they return. There is a difference in how those folks are treated by the consular post view of what public charge means, because they changed their policies somewhat. And so the main way that this is coming up for people as an extra difficulty is that in the past, you used to be able to submit an affidavit of support from your sponsoring relative, or if they didn't have the income, let's say from another family member or an employer, and that would be sufficient to show that you weren't likely to become a public charge. And now those affidavits are not given the same consideration, and sometimes folks have to submit more than one of those. So next slide. So this is a brief explanation of a regulation that you all, I'm sure, have heard a lot about. In October, the federal government published a proposed rule that would change this very clear, straightforward public charge test that depends on the benefits being cash benefits designed for income support, and that would change a lot of other factors in how the public charge test is applied. And so one of the most significant changes is that it would make certain federal benefits that are not cash and that are now omitted from public charge, it would subject them to this public charge test. And so those are non-emergency Medicaid, food stamps or SNAP, and Section 8 housing vouchers and other federal forms of federal housing. So that would have a very big impact on the population you all work with, it would on our clients at Mass Law Reform. And so 225,000 public comments were filed, mostly against this reg, and the government is reviewing those comments, and it will likely take them some time before they can respond and publish a final rule. But let's say they do publish a final rule at some point. In the text that they published, they indicated that it would only apply to these new 4 categories of benefits if the benefits are received 60 days after the changes are made effective. So there would be some time for people to prepare. So next slide.
Sure. Hi, this is Amy. So the key takeaways for this, and we've heard anecdotally from around the country that just this proposed rule and the threat of it is already deterring lots of people from getting benefits that they are in fact eligible for. So probably the big key takeaway is that these changes are proposed. They have not yet been finalized. As Iris said, there were more than 200,000 comments received on this proposed regulation, and the government needs to read through those and consider what they say. And even if they do end up finalizing the regulation, you won't be penalized for public charge for using any of these benefits until 60 days after the final rule takes effect. For purposes of this project, Ryan White program benefits don't count for public charge. They're not one of those categories of benefits. Neither are things like free HIV or HCV testing, employment services. None of those will count for public charge, even if the new rule becomes finalized. As Iris mentioned, the changes don't apply to all immigrants. So if someone is a refugee or an asylee, like public charge, this regulation is not relevant to them. There are benefits that folks who are immigrants can get now that can help them improve their ability to support themselves and be not a public charge in the future. And there really is no reason now for them not to access those benefits. So as we said, even if these changes do get finalized in a final regulation, only the list of benefits received after the rule is finalized will count against someone. So anything that anyone is getting right now or in the very near future is not going to count. And the other thing we would say is immigration law is highly technical and complicated. So if you have questions about this, you're going to want clients to talk to someone who does specialize in immigration law.
Great. Next card, or next slide. Okay, so now we're going to talk about how does a person get lawful employment authorization. Of course, immigrants work even when they don't have valid documents, but we're just going to talk about in the next slide who can be work authorized. Next slide. So there's a long list of statuses that qualify you for work authorization. So all those statuses that I went over earlier are statuses from which a person can then ask for a work permit or a card that looks like the one on the prior screenshot. But some of them do not qualify for employment authorization. They're obviously tourists are not allowed to work here. Their purpose here is supposed to be to tour the U.S., not to work. And so some of the non-immigrant categories are not eligible. But the important point is that you don't go and apply for employment authorization unless you have some underlying status or application for status upon which that authorization can be based. So most people will get an EAD and it'll be coded for their status, but in some cases there are automatic extensions. So TPS we were talking about earlier, the Trump administration declared that they were going to terminate the TPS of a number of countries, including Haiti and El Salvador and Honduras, and that was going to happen in 2019 and 2020. However, there have been lawsuits challenging the proposed termination as discriminatory, and so therefore the court has determined, the courts in those cases have determined that those TPS grants must remain in place despite this threat. So the way to establish this for an employer it might be complicated to explain is to refer them to the USCIS website, where the government explains this expanded ability of people with TPS, even that is supposed to be terminated, to remain lawfully and work lawfully beyond those dates. The other thing just to mention is that permanent residents, asylees, and refugees are not required to seek employment authorization documents. They don't need them to show an employer because they are considered to be authorized to work incident to that status as a matter of law. And the last thing I wanted to add is that if you get an employment authorization document, let's say for 1 or 2 years, because it's issued for that length of time, then the Social Security card that you get will not be the same as a person who's a citizen or a permanent resident or asylee or refugee, because it'll be legended as valid with employment authorization. So it's a different kind of Social Security card. Next slide. So now we're going to talk a little bit about the housing rules, and these are going to be primarily about federal housing and its restrictions. So next status. So the federal housing programs are divided into those that are restricted by immigration status and those that are not. And so depending on the funding that is providing that housing, they will fall into one of the lists in the next 2 slides. So I'm just going to show them to you, but you're going to have these slides, so we don't need to recite them all. So these are the programs that do not have the immigration status restrictions, which we will define in a few minutes, attached to them. So you can see actually that HOPWA, a lot of these are beneficial for your client base. In the next slide, we have the restricted programs. So the chief among these are Section 8 and public housing. So these are the ones that are subject to the immigration restrictions. So next slide. So restricted means that at least one person in the household has to be a citizen or an eligible non-citizen for the household to be able to live in that housing. So if, let's say, there's only a citizen and a group of ineligible non-citizens with legal or undocumented status, then the federal housing unit's rent is prorated so that the people who are ineligible have to pay their share. Next. So these are the primary groups of immigrants who do not have to pay a prorated share, who get the whole benefit. So people with green cards, the persecution-based statuses, parolees and LTRs, and victims of trafficking. There's one more group that isn't on here because of the way they get their eligibility is kind of unusual. And these are domestic violence victims who have self-petitioned for status under the Violence Against Women Act. in 2016, and then I think in 2017 again, HUD issued memos clarifying that even though the VAWA self-petitioners aren't listed with this group of immigrants in the Housing Act that applies to these programs, that a VAWA self-petitioner could declare themselves to be in a satisfactory immigration status. So, in fact, they can receive the full housing subsidy, and it's important because, you know, usually those are some of the folks who most need it. Okay, so the next slide. So these are some of the immigrants that we discussed before who are not eligible for the full subsidy, so that even though they may have a lawful status, they would have to pay their portion and live in a household that has somebody else who is an eligible non-citizen or a citizen. So the star at the bottom reminds you that if you have a mixed household, let's say this public charge rule were to ever go into effect that made federal housing a benefit that public charge applies to, even if these folks in these other statuses are part of the household, they would not actually be considered to be receiving the benefit. So the public charge rule really shouldn't be relevant to them because they have been paying their share. Next slide. State housing, here in Massachusetts, we do have state housing programs. I know that not many states do, but it is worth mentioning that that immigrants who are not eligible for the federal housing may still be eligible for state housing. And secondly, that if a state asks for an SSN, a Social Security number, for whatever purposes, they may well be able to ask, but they're not, it's probably, or it may be unlawful under federal law to make it a condition of receiving state housing if they are not eligible for a Social Security number and haven't been issued one. And I also wanted to point out that housing authorities in states that do have state programs often have a unified application so that the person applies for both the federal and state. So even if they are disqualified from the federal, then they could be bumped to the state. And then for Massachusetts, we have a manual that explains more of the eligibility rules for Mass. If you're interested, you can look it up. It's available online. So that's the end of my piece.
Wonderful. Thank you so much, Iris. That was wonderful and really informative. We've been getting some questions in our Q&A section of the webinar. So we encourage folks to still type in your questions if you have any. And if it's okay with you, Iris, Amy, and Marianne, we can read some questions for you that folks have.
I think Amy and Marianne might have a few more, just want to go over these last few slides.
Cool.
Well, sure. We just wanted to bring up the learning objectives to describe some of the some of the goals that we had with this webinar, really to describe some of the common types of immigration statuses, to talk about the public charge and the proposed changes, and to give you a glimpse as to how someone's immigration status may affect their opportunities and ability to work in secure housing. But as the previous slide stated, you know, if anything, we hope you understand that this is all a really complex area of law, and to best serve your clients, it's important to connect with a culturally competent law firm or legal aid service in your area, so that you can refer clients when they do have questions. And then the next slide, one of our last slides, just includes some more resources that you might find helpful. The Massachusetts Law Reform Institute, where we're speaking from right now, has some great online tools. There's also the National Immigration Law Center, which is also one of the leading organizations behind protecting immigrant families, which is a great one-stop resource for all related to the public charge. And then we've also included the U.S. Citizenship and Immigration Services, which can provide some official information and also has some tools resources that can be helpful, such as pictorial examples of what some of these documentation, what these documents can look like. And then finally, we did want to give a plug to some fellow organization, the AIDS United, Positive Women's Network USA, and the National Immigration Law Center are going to be hosting a webinar looking specifically at how public charge may affect immigrants living with HIV. So if you're interested in getting a second go around of this information and looking more at advocacy resources, definitely feel free to visit that link and register for the webinar.
Thanks, Marianne.
Okay, and now to the Q&A. Sorry to cut you short. We have a few questions right now. So one is from Sylvia from Yale University. She says that we have a few people in our housing programs without documentation. They were admitted when the subsidy provider we worked with had a don't ask, don't tell approach. Now people have to provide documentation of their status. We have a person who was recently referred who has paperwork that indicates an employment authorization card that is expired. He also has a document that shows he met with ICE in November and is due again to meet in April. The paperwork has the signature of an ICE agent. A letter accompanies this with the April date. In no place does the paperwork label his status. Do you have any idea what this is? We are not focusing on employment at this moment, only housing and providing documentation of his legal status here in the U.S. If you cannot assert what this means from my description, would you tell me who to ask? What resources are in communities to get clarification?
Sure, this is Iris. So first of all, I would look at the employment authorization card, and the face of the card usually has a code that starts with A or C and then a number. And that will refer to the underlying immigration status upon which that employment authorization was based. Now, the card may have expired, but maybe the underlying status hasn't. So that it's just that it was issued for, you know, a defined period. So that's one suggestion. The contact with ICE could be that the person, there are many situations where the person has a status application pending, but they still have to report to ICE periodically. So that could be a reporting obligation, which suggests that their underlying status would not be a status that was a finally adjudicated one for, let's say, federal housing purposes, but they would still probably be lawfully here in that position. So I would say that depending on what state this person is in, with the client's permission, you could scan and fax the documents to a provider of immigration legal services and ask them for information to help you read the documents and ascertain the person's current status.
Wonderful, thank you. So we also have a question. So someone asks, if someone has a 2-year temporary green card with the right to work, which expires in the next month, and then applied for a 10-year green card during the government shutdown, how long will it take for approval, and can they still work after the 2-year card expires and are waiting for the 10-year to be approved?
Yeah, so the people with the different versions of the card are still permanent residents. When they get the 2-year card, they're still a permanent resident. Even though it says conditional on it and the card has this extra step that they have to go through to remove the condition. So as long as they have timely complied with their obligations under the law, they should continue to possess their lawful status. And I can't really answer how long question, because the whole adjudication system at immigration has gotten completely backlogged. It's really, you know, a disgrace, honestly. But I would say, though, that once again, I would look at the to determine if the person has complied with what they were supposed to do to remove the condition in a timely fashion. To ascertain that, I would, again, with their permission, scan that and review that with an organization that provides these kinds of legal services to immigrants.
Awesome, thank you. I have one more question, and I encourage people to still type in your questions if you have any. We have one from Angelo referring to federally funded housing. So you said that at least one person has to be living in the housing program. Can this person be the child of the person applying for this housing, or does that person need to be an adult?
No, in fact, U.S. citizen children were the primary reason that those mixed household grant procedures were put into effect, because there was a lawsuit many years ago that challenged the effect on U.S. citizen children of having imposed rules that would require the family to abandon their child or split up or, you know, forego something that the child was eligible for.
Great. Well, thank you so much for those questions, folks. We don't have any more that are popping up in the chat. So I just wanted to, before signing off and thanking everyone for their participation, I just wanted to circle back and see if any of our presenters have any final words for our attendees or thoughts.
Just as far as resources, in Massachusetts, on the Mass Legal Help website, which is a public website that doesn't have, you know, password restrictions on it, there is a list of credible referral sources that includes all the legal service programs in the state and other organizations that provide immigrant legal services. And I assume that in the other states where these participants are located, that there may be similar websites. If you start with the legal aid websites, even though some legal aid offices don't do immigration, they may have referral lists for immigration legal services providers on their website. So I would encourage you to look there when you're looking for resources.
Thank you, Iris. And Amy or Marianne, do you folks have anything else to say before we sign off?
I mean, I guess we would just reiterate that immigration law is very technical and complicated. those of us with law degrees who don't practice immigration law turn to people like Iris who do for expertise, so bear that in mind. And I guess also we will talk to folks in a couple of days on the legal technical assistance cohort call.
Yes.
And we'll post the slides and the links to the resources on Basecamp so that they're readily available when you need them.
Fantastic. That's what I was going to say, you guys. So just wanted to remind everyone of our, oh, I'm going too far, sorry. Of our resources, the ones that we have available to us, which include not only Amy and Marianne, who are part of our evaluation and technical assistance provider team, but that we also are connected to Iris now after this webinar. So thank you, Amy and Marianne, for pulling all of this together and for reaching out to Iris. Iris, thank you so very much for all of this information. I know it's incredibly helpful for our sites and for the clients that our programs serve. So really phenomenal. I want to reiterate what they just said, that we will post all of this information on our Basecamp, and as usual, make available the recording of the webinar, plus all of the resources. We'll provide links. These links we'll put back up on the Basecamp itself as well, so you can just directly link to those. And to remind everyone that we also have our next webinar that's upcoming for Tuesday, March 26th, so essentially just a month from now, is on program sustainability and integration. So we really hope that you all will remember that we're sending out a calendar invite today, and just remember that this is a really important topic that HRSA would like us to really strongly consider spending a lot of time thinking about and planning for sustainability of our programs, and then integration into the larger Ryan White system. And so we'll be talking about strategies for that on our next call. I'm sorry, on our next webinar. So with that, are there any other questions? Just to double check in the chat or anything? Wonderful. Well, thank you all so very much. Again, thank you to our panelists. Thank you also to Jane Fox, who actually had to jump off the call, for being our lovely host. And we will catch you all next month. Thank you again.